I want you guys to see this. This is from Chief Justice of the Supreme Court, Howard Taft, in 1925. The language, I better zoom this in just a little more. The language of the Constitution cannot be interpreted safely except by reference to the common law and to the British institutions as they were when the instrument was framed and adopted. The statesmen and lawyers of the Convention who submitted it to the ratification of the Convention of the 13 states were born and brought up in the atmosphere of common law, and they thought and they spoke in its vocabulary. They were familiar with other forms of government, recent and ancient, and indicated in their discussions early that many of them, when they studied them, but they came to the conclusion that to any form of fundamental law in a compact draft, they expressed themselves in the term of common law, confident that they would be shortly and easily understood. And now you've seen that. Let's go on to something else here. Now, what he was saying was they've got to look at the old, what's the best evidence. And that's like if you have the original document, okay, well they do have all that, all the old stuff, and it's called the Federalist Papers. That is the best evidence. It gets a higher degree of credibility than anything else. They've got to go by them Federalist Papers to understand the Constitution. Let's talk about the Constitution just for a minute. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement with it. It's impossible for a law which violates the Constitution to be valid. All laws that are repugnant to the Constitution are null and void. You know, every single firearm law or anything that has a firearm law in it is null and void. Where rights are secured by the Constitution, your Bill of Rights, where the rights are secured by the Constitution are involved, there could be no rulemaking or legislation which could arbitrate them. An unconstitutional act is not law. It confers no rights, it imposes no duty, affords no protection, it creates no office, it is illegal, it's like it's inoperable, like it never had been passed. General rule is that an unconstitutional statute, although having the form and name of law, is in reality no law. Okay? No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Let's go to something else here. So I've said this to, I think it was Jamie the other night. I was trying to tell him something. But here you go. Title 18, Section 2381. Capital felony treason. In the presence of two or more witnesses of the same overt act or in open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. You fail to move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. I just wanted to get this out there so you understand, where all this stuff is coming from. Looky here. Although it is manifested as unconditional provision in the statute, is not cured by and includes the same act. Okay. No, I think it's the next one. Yeah. Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Now that capital felony thing, if upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. Okay, so we got through this. Well, I'll make this a short video. I just wanted you to know how the laws read. Thanks.